Be ready. 5 seconds.
This petition seeking leave to appeal has been filed on behalf of the state challenging the impugned judgment whereby the learned trial court has acquitted the accused/respondent herein. Stop. Complaint was filed by Delhi administration through local health authority against the respondent for prosecution of offence under section 16(1)(c), read with section 7 of Prevention of Food Adulteration Act. Stop. Complaint was submitted alleging that when food inspectors of the department under the supervision of LHA and under orders of the director of the department, went to the shop for the purpose of lifting samples of food articles suspected to be adulterated, for the purpose of analysis, one person was present there. Stop. He was found conducting business of the shop, wherein variety of food articles were stored for human consumption. Stop. On coming to know of the identity and the purpose of visit, respondent became furious and refused to permit the team to take the samples. Stop. Matter was reported to the police station, upon which case FIR was registered against the respondent. Stop para. As per the case of the petitioner, respondent prevented the public servants, from taking samples of food articles for analysis and assaulted and obstructed them in lawful discharge of their duties, thus committing an offence punishable under section 16(1)(c) of PFA Act. Stop. After investigation was concluded, entire case file including statutory documents and report of the FI were sent to the director PFA Delhi administration, who accorded consent under section 20 of the PFA Act for institution of the case, and present complaint was filed. Stop para. Summons of the case were served upon the respondent, and upon his appearance, notice was framed, to which the respondent pleaded, not guilty, stop para. Learned trial court vide impugned judgment acquitted the respondent of the charge, giving benefit of doubt. Stop. Bail bonds of the respondent were cancelled and surety was discharged. Stop para. On the issue of non-joining of public witnesses under section 10(7) of PFA Act, the trial court held that no efforts were made by the complainant to call any public witness at the time when the team entered and inspected the shop for lifting the sample, which is fatal to the complainant's case. Stop. To come to this finding of fact, trial court relied on the testimonies of the witnesses PW1 and PW2, who were members of the raiding party and who deposed that before inspecting the food articles in the shop, they did not associate public witnesses. Stop. Trial court relied on the judgment of the Supreme Court reported as Shri Ram Labhaya versus Municipal Corporation of Delhi and another, 1974 PFA cases SC 102, wherein it was held that provisions of section 10(7) are mandatory and cast a duty on the food inspector to call one or more persons when he takes action. Stop. Certainly, if the public persons do not join after efforts are made by the food inspector, prosecution cannot be faulted with. Stop para. Coming first to the contention that trial court has erroneously delved into finding out whether respondent was the partner, I find merit in the same, and to this extent the observations of the trial court cannot be sustained. Stop para. Seen in the light of the aforementioned judgments, there is merit in the contention of the respondent that in the facts of this case, comma, non-compliance of section 10 bracket 7 cannot be ignored. Stop. As noted above, comma, the section is a safeguarding provision. Stop.